Today, the committee welcomes Glenn Fine, the Inspector General of the Department of Justice, to discuss the findings of his office's investigation into the hiring of attorneys for key career positions throughout the department. The report the Inspector General released this week, along with a previous report released last month, shines much light on hiring decisions at the department. And for years, those decisions have been shrouded in a shadow cast by the Bush White House. The reports confirm what I and others have suspected all along, that senior officials within the Department of Justice used illegal political and ideological loyalty tests in making hiring decisions for career positions by law and the department's own rules. Law and the department's own rules are supposed to be nonpartisan. They broke the law. They did so as political partisans and cronies. And I'm convinced that the U.S. attorney firings and their cover-up and the widespread illegal hiring practices within the Justice Department that have been revealed represent the most serious threat to the effectiveness, the professionalism, and the independence of the department since Watergate. We learned through the course of our investigations of the firings of the U.S. attorneys that only loyal Bushies would ultimately keep their jobs, to use their words. I hear people being asked not how you can serve your country, how you can serve the Department of Justice, but how do you serve George W. Bush? You're there to serve the country, not any individual president, Republican or Democratic. Last month, we saw that political functionaries under Mr. Ashcroft and Mr. Gonzalez corrupted the honors program for the best and the brightest coming out of law schools. The honors program being something where we have looked to recruit career people in the Department of Justice by picking only the very, very best, irrespective of their political background. But here, they turned it into something that no matter how talented you are, you could only apply if you're a demonstrably loyal conservative Republican. Now we see in the reports of the Inspector General that our worst fears are also realized in the department's hiring and assignment practices for nonpartisan attorney positions, those of immigration judges and prosecutors. Why would you be seeking a partisan immigration judge or prosecutor? The law is the law. It doesn't make a difference which party you belong to. We actually have laws against doing such a thing, and those laws were broken. As a former prosecutor, I'd hoped the Department of Justice would take its responsibilities seriously now and hold people accountable. Only then will the department move forward to help ensure this never happens again. Something should be done now. We don't know who the next president is going to be, but no matter who it is, we should establish the criteria so this never happens again. But I have yet to see any such response from the current leadership of the department. And one of my questions to Mr. Fine today is whether the Inspector General has made referrals to the prosecuting arm of the department for further investigations and possible prosecutions. The Inspector General's reports confirm that senior officials report to the office holders at the highest levels at the Justice Department, and it also interacted with the White House, sacrifice the independence of law enforcement and the rule of law and allegiance to this current administration. The key question should be whether the applicant is qualified for the job. However, and I've referred to this already, according to the report, the key question for Monica Goodling, the department's White House liaison, and others was, what is it about George Bush that wants you to serve him? It'd be a lot better, what is it about the cause of justice that makes you want to serve the cause of justice? Federal prosecutors and immigration judges take an oath of office, but that oath is to the Constitution, not to an individual person. They are to serve justice and the American people. This administration has had it wrong from the outset, and all of us, but especially our institutions of government, have been the victims. There are chilling examples in this week's report that show the danger of putting loyalty to a certain office holder above the duty to enforce the law. The report documents one instance where an experienced career terrorism prosecutor was rejected by Goodling for a detail to the Executive Office of U.S. Attorneys to work on counterterrorism issues because of his wife's political affiliation. So we lose a very, very experienced person because his wife dared to have a political affiliation of her own. And so the Executive Office of U.S. Attorneys had to select a much more junior attorney who lacked any experience in counterterrorism issues and who those officials believed was not qualified for the position. It's almost as if we hit the replay button on the tragic aftermath of Katrina, where cronyism was valued over competence. According to the report, the system put in place by the Chief of Staff of then Attorney General Alberto Gonzales for selecting immigration judges, appointments by law or non-political, was the most systemic use of political or ideological affiliations in screening candidates for career positions that occurred. The department's practice not only subverted the law and placed political loyalty above fairness, it caused serious delays in filling immigration judge positions, just as the workload and importance of those judges was increasing. And the report reveals that the principal source for politically vetted candidates considered for these important positions was the White House, demonstrating the extent of the political reach of the White House into the department's career ranks, an unprecedented activity. There can be no remaining question this administration encouraged politics to infect the department and law enforcement. The question, of course, I have is what will Attorney General Mukasey and the President do about it to provide accountability? In our oversight hearing earlier this month, Attorney General Mukasey essentially dismissed the findings of last month's report as the actions of just a few bad apples. That reminds me of the administration's ongoing attempt to place the blame for the actions at Abu Ghraib solely on the soldiers of a few, or on the shoulders of a few soldiers there, rather than see those excesses as a consequence of the policies and practices put into place by the President, the Department of Justice, and the Pentagon. This week's report, like the one that preceded, makes clear that the problems of injecting politics into the hiring decisions of the department are rooted deeper than just the actions of a handful of individuals. Even with blanket claims of privilege and immunity from the White House, in their effort to try to cover up the truth, we continue to learn about the unprecedented improper reach of politics into the department's professional ranks. There's only so much they can do to cover up. The truth does come out. And by infusing politics into the hiring of career assistant U.S. attorneys positions, senior career attorney positions, Main justice detailees, young career attorneys, and immigration judges, this administration and its operatives have done serious damage to the rule of law. The American people look forward to a serious response from the current leadership of the Department of Justice. Senator Specter.
Thank you, Mr. Chairman. At the outset, Mr. Fine, I thank you for your work on these very important matters. The independence of an Inspector General is demonstrated by the work you have done here and the last appearance before this committee on detainees, and underscores the importance of Inspectors General in so many of the departments to bring an independent look at the issue, to call it as it is and let the chips fall where they may. And there's no doubt that when we're dealing with positions like immigration judges or the Board of Immigration Appeals, that political considerations ought not to be a factor. The investigation so far has dealt with people who are not at the top of the ladder in the Department of Justice. And it raises a question in my mind as to whether others were involved. You have Monica Goodling, and you have Kyle Sampson, and you have John Nowacki, all of whom occupied important positions, but not the key positions. When you were before this committee a few weeks ago on the issue of detainees, I expressed my concern about the thoroughness of your investigation on questioning the director of the FBI, Robert Mueller, from the point of view of the FBI disagreeing with the CIA interrogation tactics, which was a good sign of independence, but what further did Director Mueller do to try to stop it? What effort did he make to take it even to the president? And I believe that it is very important that the investigations go to the very top if that's where the facts lead, and that's a subject which I will want to hear you on when the time comes for questions and answers. The issue arises as to whether there is potential for a criminal prosecution. And when this the story broke in the media, of course, the media wants to know instantly with the telephone calls, do you favor criminal prosecutions? Well, my response was, I'd like to know what the facts are first. That's not a very satisfactory answer. It doesn't make the early editions. And I've read conflicting reports on whether violations of the civil service laws give rise to a criminal prosecution. Apparently they do not, but that's something we have to check. Or there's a question of false statements. And I know some members of Congress have already condemned some of these individuals on those grounds. And we have to take a very close look at what the facts are to see what is going on. I'm glad to see Attorney General Mukasey acting to change these practices. I'd like to see, frankly, a very forceful statement out of the Department of Justice as to what they intend to do and what they think about it in some detail. They have the prosecution responsibility. You don't. I'd like to see the Department of Justice speak emphatically on this subject. So there's a great deal we have to look at here. One aspect of the report which I think is highly significant are the compliments which went to Acting Attorney General Peter Keisler. Keisler is quoted as saying, quote, "You should have known that there's a lot of people who believe that these deselections are either irrational or so irrational they are motivated by politics. And that's a problem, as you know," close quote. So here's a top, had been Assistant Attorney General, then was Acting Attorney General, speaking out against his party, kind of a healthy thing in Washington when that is done on occasion. Isn't done often enough when the facts warrant it. And then the report came to this conclusion. Acting Attorney General Keisler spoke with Mercer and advised him that the review process had been problematic and that many people in the Civil Division believed it had been politicized. Keisler told Mercer that at the appropriate time he would like to have a meeting with senior department officials to discuss the next year's hiring process to ensure that the problems they encountered in 2006 would not be repeated, close quote. Well, I read that because the nomination of Peter Keisler is pending before this committee, and he's waited a long time. And the question is qualification. And when you have this kind of independence exhibited by Mr. Keisler and recognized by the Inspector General in what is otherwise a very lurid situation, I think that's something special. It reminds me of an incident long ago when there was a prosecuting attorney in New Jersey named Brendan Byrne. Senator Biden will remember this, and Senator Leahy will remember this. So sometimes they comment about the aging senators. Of course, it's not true, but it's good to have a little corporate memory. But Brendan Burns' name was picked up on an FBI tape, and the mob was talking about Brendan Byrne. And they say, the problem with Byrne is he's honest, which is something rare for somebody in North Jersey at that time. He's saying, well, business got so bad the mafia had to lay off several judges in North Jersey. I was DA at the time. That Brendan Byrne was the district attorney. Biden had already gotten to the Senate at the age of 19 or some such age. But that established Brendan Byrne's reputation. Leahy and I had.
If you'd yield, I served the board of the National DA Association with Brendan Byrne.
Well, you and I aren't old timers, Patrick, but we have some corporate. Joe Biden was a public defender. He didn't get to be a prosecuting attorney. But I mentioned Brendan Byrne because his reputation was established. They named a big basketball arena after Brendan Byrne. And Keisler's almost in Byrne's category, maybe enough to attract the attention of the chairman of the Judiciary Committee. Well, I've talked at some length. Regrettably, I can't stay for this entire proceeding because we're on the floor with the Reporter Shield bill, which is my bill, and it's coming up for a vote, and I'm due to speak on it shortly. But I'll be following your testimony very closely on this very important subject, Mr. Fine. Thank you.
Thank you. And we'll start with Glenn Fine. I know that Senator Biden wanted to say why he has to leave.
Mr. Chairman, thank you first for holding the hearing.
It's not that we don't love you, they're all leaving, but go ahead.
Well, this thing about corporate memory, I've observed that corporate memory at the time, that assumes you have a wealth of experience and memories that go back. The problem is the older you get, the harder it is to recall them. Mr. Chairman, thank you for the moment. Mr. Fine, I just wanted to explain to you, after your testimony, we'll be leaving. I chair another committee, and the Prime Minister of Pakistan is our witness, not our witness, our guest, and so that's why I'll be leaving. And I would associate myself with the remarks of both my colleagues. Facts do matter. It is important. And the one central thing, if I don't get a chance to ask you questions, maybe I can submit a few in writing. For me, in my experience of 7 presidents, it's not often that someone at Golding and Sampson's level are able to have this kind of latitude without someone above them instructing them. I'd very much like to know where this goes as the senator from, if it goes anywhere, as the senator from Pennsylvania indicated. But I thank you, Chair.
Thank you very much. And we will find out. And note that Glenn Fine was confirmed by the United States Senate as the Inspector General for the Department of Justice on December 15, 2000. He's worked for the Department of Justice Office of the Inspector General, OIG, since January 1995, initially Special Counsel of the Inspector General. Before joining the OIG, Mr. Fine was an attorney specializing in labor and employment law at a law firm in Washington. Prior to that, he served as an assistant U.S. attorney in the Washington, D.C. U.S. Attorney's Office. He graduated magna cum laude from Harvard College in '79 with an A.B. Degree in economics. While he was getting that magna cum laude degree, so people wouldn't think he was solely studying, he was co-captain of the varsity basketball team. He was drafted by the San Antonio Spurs of the NBA. I see a smile. I think there's probably days he wishes. Mr. Fine was a Rhodes Scholar. He earned his BA and his MA degrees from Oxford and received his law degree, magna cum laude, from Harvard Law School in 1985. Mr. Fine, please go ahead, sir.
Underachiever.
Thank you, Mr. Chairman, Senator Specter, members of the committee. I appreciate your invitation to testify at this hearing about 2 reports recently issued by the Office of the Inspector General and the Office of Professional Responsibility on allegations relating to politicized hiring at the Justice Department. Our first joint report, issued on June 24th, examined hiring practices in the Department's Honors Program and Summer Law Intern Program. The second report, issued on Monday, examined allegations that Monica Goodling and other staff in the Attorney General's office inappropriately considered political affiliations when hiring for career department positions. With regard to the first report, the Department's honors program is the exclusive means by which the Department hires recent law school graduates. These are career positions, and therefore Department policy and federal civil service law prohibit discrimination on the basis of political affiliations. However, the evidence in our investigation showed that a screening committee established by the Department in 2002 deselected for interviews those candidates with Democratic Party and liberal affiliations apparent on their applications at a significantly higher rate than applicants with Republican Party, conservative, or neutral affiliations. This pattern continued even when we compared a subset of academically highly qualified candidates. From 2003 to 2005, the screening committees made few deselections, and these decisions could reasonably be explained on the basis of candidates' academic qualifications. However, we found that two members of the 2006 screening committee, Esther Slater McDonald and Michael Elston, inappropriately considered political or ideological affiliations in deselecting many candidates. As just one example, and many more discussed in our report, McDonald and Elston deselected an honors program candidate who was first in his class at Georgetown Law School, had clerked for a judge on a U.S. District Court, and was clerking for a judge on the Second Circuit Court of Appeals. However, this candidate had also worked for a Democratic U.S. Senator and a human rights organization and was deselected. We concluded that McDonald's and Elston's actions constituted misconduct and violated Department policy and federal civil service law. Our second report, issued on Monday, described the results of our investigation into actions by Monica Goodling and other staff in the Attorney General's office. We concluded that Goodling regularly considered political affiliations in screening candidates for career positions at the Department, which also was misconduct and violated Department policy and federal civil service law. For example, in one instance, the interim U.S. Attorney in the District of Columbia sought approval from Goodling to hire an Assistant United States Attorney for a vacant position. Goodling responded that the candidate gave her pause because, judging from his resume, he appeared to be a liberal Democrat. Goodling also said she was reluctant to approve the request because she expected that Republican congressional staff might be interested in applying for AUSA positions in Washington. Only after the U.S. Attorney objected was he allowed to hire the AUSA. In addition, Goodling often used political affiliations to select or reject career attorney candidates for temporary details to department offices. This was particularly damaging to the department because it resulted in high-quality candidates for important details being rejected in favor of less qualified candidates. In perhaps the most troubling example mentioned by Senator Leahy, an experienced career terrorism prosecutor was rejected by Goodling for a detail to work on counterterrorism issues in the Executive Office for U.S. Attorneys because of his wife's political affiliation. Instead, EOUSA officials had to select a more junior attorney who lacked experience with counterterrorism issues and who the EOUSA officials believed was not qualified for the position. The most systematic use of improper political or ideological affiliations in screening candidates for career positions occurred in the selection of immigration judges. Under a new process implemented by Kyle Sampson in 2004, immigration judge candidates were treated as political appointees. Goodling used a variety of techniques for determining candidates' political affiliations, such as researching their political contributions and voter registration records and using an internet search string that contained political terms. Not only did this process violate the civil service law and department policy, it also caused significant delays in appointing immigration judges. These delays increased the burden on the immigration courts, which already were experiencing an increased workload and a high vacancy rate. Both prior to and since issuance of our two reports on politicized hiring, the Department has taken steps to attempt to prevent the serious problems raised by these actions from occurring again. Attorney General Mukasey has agreed to implement all the recommendations of our reports. Finally, I want to note that the OIG and OPR are now jointly investigating allegations related to the removal of several United States attorneys, as well as allegations that Bradley, Schlossman, and others used political affiliations in hiring and personnel decisions in the Department's Civil Rights Division. Because these investigations are ongoing, I should not discuss them. However, I want to assure the committee that the OIG and OPR are working very hard on these investigations and will issue our reports as expeditiously as possible when those investigations are complete. In conclusion, I believe that the Department must ensure that the serious problems and misconduct we found in our 2 reports about politicized hiring for career positions in the Department do not recur. Implementation of our recommendations and vigilance by current and future Department leaders can help prevent a recurrence of the serious misconduct and violations of Federal Civil Service law and Department policy that are described throughout our reports. That concludes my prepared statements, and I would be pleased to answer any questions.
Thank you very much, Mr. Fine. According to your report, Monica Goodling, the Department's White House liaison and senior counsel to the Attorney General, had a number of techniques to screen hires for political and ideological loyalty, especially loyalty to the President. And I remember we brought this out at a hearing with us. You'd ask questions of applicants such as, what is it about George W. Bush that makes you want to serve him? Seems unusual because usually people ask, what is it about the United States government that makes you want to serve in the United States government? Kyle Sampson, then Chief of Staff to Attorney General Gonzalez, put into place a system for screening and selecting immigration judges that funneled Republican loyalists, the principal source of which was the White House, into these positions. Now, in the course of our investigations into these matters and the firing of U.S. attorneys, and despite substantial evidence showing White House involvement in the firings, in the effort for politically motivated prosecutions, and in response to congressional inquiries about these matters, the President has invoked a blanket and unsubstantiated claim of executive privilege to avoid complying with our subpoenas, prevent Karl Rove and Harriet Miers from even appearing to testify here in the House. Now, I take it you were not allowed to interview either Mr. Rove or Ms. Miers?
We did not interview Mr. Rove or Ms. Miers in this investigation. As we discussed in the report, we were able to interview someone in the Office of Political Affairs at the Department who was involved with Goodling and Williams in selecting immigration judges. We did interview him. From the indications that we saw in both the emails to and from the Department and from the testimony of the Department, we did not see indications that it went higher to Mr. Rove or Ms. Miers. There is one instance in Mr. Rove was involved, and that is he recommended an immigration judge for a vacant position in Chicago, and it was clear that he was pushing for this candidate. This candidate eventually was selected.
And the 2 reports you've issued so far have concluded that a broad set of high-level Department officials were involved in the illegal political and loyalty screening career hires, including the former acting Associate Attorney General, former Chief of Staff to the Attorney General, the former White House liaison, and senior counsel to the Attorney General, 2 other former White House liaisons, the former counsel to the Associate Attorney General, the former Chief of Staff to the Deputy Attorney General, and the current Deputy Director of the Executive Office of U.S. Attorneys. Now, these officials include the number 3 official of the Department, Chiefs of Staff to the Attorney General, the number 2 official. In fact, the complaints that were raised were ignored. The reason I ask this is because at our oversight hearing last month, Attorney General Mukasey characterized the findings of your first report in this way. He said, I found that the IG report reflected that 2 people currently employed by the Department, one of whom is no longer in the job that he's in, had failed to respond with sufficient alacrity to charges. I don't want to interrupt the conversation next to me here. Failed to respond with sufficient alacrity to charges of politicization. And that's very different from saying that I found a politicized department. I wonder if you agree with his characterization of the conclusion of your reports. Was this a problem limited to just a few bad apples who failed to respond with sufficient alacrity, or a more serious and systemic problem?
I think this was a serious problem that had implications throughout the Department of Justice. The ones who committed to wrongdoing. We identify in the report, both in our honors program report as well as in our report on Monica Goodling and others. It had a significant effect throughout the department. I think one of the significant things was people not objecting, people not standing up. Senator Specter alluded to this. A few did, but most didn't. And I think that was one of the significant problems that we found in the report. Another significant problem that I think is important to note is the lack of oversight of these people. These were inexperienced, junior people to some extent. They rose to high-level positions, and they were allowed to implement these actions and changes unchecked, without adequate supervision, without adequate oversight, and it resulted in very serious damage to the Department of Justice. So I think it is a systemic, important issue that needs to be addressed.
In fact, these say rose to these high positions. I mean, these are positions where normally you have a great deal of experience and institutional knowledge before you're put in these positions. Is that correct?
Well, sometimes they do, but I think in this case there were a significant number of ones who didn't have experience for the job that they were put in. I'll give you an example. In the honors program, a very important program in the Department of Justice, and the screening of candidates for that is very important. Many of the people who apply for this honors program remain with the department for much of their career. It is a career position. It is the backbone of the Department of Justice. So they set up a screening committee, and in 2006 they assigned Esther Slater McDonald to be on the screening committee, and she had been in the department for less than a month. She was a junior attorney. She was not even given instructions on what to look for and overseen in her actions. I think that's negligent. I think that's not appropriate, and that on these important programs there needs to be better oversight and supervision. It didn't happen.
It's interesting because when I was recruited by the then Attorney General, when I was a law student, he made it very, very clear that politics would not be allowed in these professional positions, and that the White House could not interfere with them, could not interfere with the prosecutors, could not interfere with these decisions. And that was Attorney General Robert Kennedy, who, if there was anybody who might have close ties to the White House, he would. And your report documents many examples of the use of code words by Ms. Goodling and others as a stand-in for political loyalty or ideology to eliminate candidates. Ruth Marcus noted in the Washington Post this morning the term good American was understood to be a stand-in for Republican, and was used, for example, by then the interim U.S. Attorney Brad Schlossman to persuade Ms. Goodling to approve his choices for career prosecutor positions. Perhaps the most egregious example is used by Ms. Goodling and others of Internet searches designed to obtain political and ideological affiliations. Here's one example of a LexisNexis search used by Jan Williams, Ms. Goodling's predecessor's liaison to the Bush White House. Yeah. It's I think if I was in a position like that, I'd be looking more, does this person have experience? If they're going to be a prosecutor, have they had experience in trying cases, making decisions? Do they have a law enforcement background? This seems to be anything but, or am I reading too much into this?
No, I don't think you are reading too much into it. The problem was screening for political considerations is not improper for political jobs. It is improper when it's used for career jobs, and that's when it was used here.
That's right.
And they did use code words, and you gave the example of Bradley Schlossman. He did talk about trying to get approval to hire AUSAs when he was the interim U.S. Attorney in Missouri, calling them rock-solid Americans, hugely positive legacy for this administration. He described the candidates in terms of their conservative credentials and involvement in the Bush-Cheney campaign, hardcore in the most positive sense of the word, and then Goodling gave him permission to hire one more good American. That has nothing to do with your qualifications to be an assistant United States attorney. Another example, there was an official who wanted to apply for the Office of Legal Policy. She was asked and was told that the Office of Legal Policy provides advice to the Attorney General, and is expected to receive advice consistent with his policies and beliefs. This candidate scratched his head and said, that's not my understanding. To himself, my understanding is that it should be consistent with the law. And that's the troubling aspect of this. That's what should be considered, their qualifications, their academic qualifications, their background for career positions. And we found many instances where it wasn't. That's very troubling, very damaging.
Thank you. Senator Spector.
Thank you, Mr. Chairman. Mr. Fine, did the conduct of Monica Goodling or Kyle Sampson or John Nowacki in politicizing the appointments of people like immigration judges or members of the Board of Immigration Appeals, did that constitute a violation of criminal law?
I don't believe it did, Senator Spector. I believe it violated the Constitution of Department policy and federal civil service law, which is civil law, but not criminal law. It's not a criminal statute.
Was there anything in your investigation to suggest that there's a basis for criminal prosecutions for making false official statements?
We looked at that carefully in our judgment and the judgment of prosecutors, experienced prosecutors who worked on this case for us. We did not think that there was a sufficient basis for a criminal prosecution for false statements for anyone. We also noted, we don't think that Monica Goodling made false statements to Congress, but we also noted she has immunity, and sort of the use of any testimony or the fruits of any testimony would be prohibited. But having said that, I will say that we do not believe that the conduct that we found in our report constituted a criminal violation. It was a violation of civil law and department policy.
Was former Attorney General Gonzalez questioned on this matter?
Yes, he was.
And what did he say?
He said he wasn't aware of what was going on. He said he did not know Goodling used political factors when assessing candidates for career positions, did not know the search terms Goodling used, did not know even that Goodling's portfolio included hiring for IJs, and basically said he didn't have knowledge of the role of the Office of the Attorney General played in identifying candidates and was not involved in the selection of these immigration judges. He said the first time he became aware of problems or complaints in the honors program was in April 2007 when there was an anonymous letter provided to Congress in public, and when he heard about that, he told the Deputy Attorney General to fix it. That was what he said.
Were Goodling, Sampson, and Nowacki questioned as to former Attorney General Gonzalez's participation in any of these matters?
Yes.
Attorney General Gonzalez denied. I see you turning back. Do you have a modification of that answer?
Yeah. Goodling was not questioned by us. She refused to be interviewed by us. She was questioned by the House Judiciary Committee.
During the Judiciary Committee hearings on the U.S. Attorney's issue on replacement, the Attorney General Gonzalez at that time denied knowing anything about that, and his testimony was contradicted by a number of people. But you're saying that that did not happen here.
Not saying exactly. Saying it did not happen here. We are looking at the removal of U.S. attorneys, as I mentioned in my statement. We are looking at that very carefully, and we'll view all the issues in that one.
And what White House officials, if any, were questioned on this issue of politicization of appointments?
Scott Jennings, who was in the Office of Political Affairs at the White House and who had the contact with Monica Goodling and her predecessors, who were the White House liaisons of the Department of Justice and provided candidates to the department for these positions, particularly for immigration judges.
And why were no others at the White House questioned?
From the evidence that we had, both emails, both discussions, we did not see that the others were involved in this process, and we questioned the person who was involved.
What steps have been taken by the Department of Justice, to your knowledge, at the present time to avoid a recurrence of this kind of a problem?
They have taken steps both when the issue arose back in April 2007 and also in response to our report to prevent a recurrence of this. For example, they have put back in Executive Office for U.S. Attorneys the decisions on waiver applications by interim U.S. attorneys who want to hire AUSAs. It's not the Office of the Attorney General who decides it anymore. It's EOUSA officials, and they only decide it based on financial considerations. In addition, immigration judges are screened by a process that is in the Executive Office for Immigration Review by the officials there, the career officials there. They're rated, they're interviewed, and it is not with the political people in the department anymore. In response to the honors program, they have ensured that the screening committees are done by career officials. They're done at the Office of Attorney Resource Management. If there are any deselections, it's based upon academics, and if there's anything else, there has to be listed reasons why it happened. In addition, the screening officials have to certify that they're only going to use merit-based principles, not political considerations, that they understand those principles and will use those principles. They've changed the Department of Justice Human Resources order to make that 100% clear, and they are considering training for officials involved
Mr.
in the
Fine,
screening process.
I don't have much time left,
Okay.
and I want to cover one other subject. Elaborate upon the activities and conduct of Mr. Peter Keisler with respect to this issue.
As you pointed out, we credited what he did in this case. He received complaints from people who worked for him in the civil division about deselections that were completely irrational. These were highly qualified candidates and were deselected. He went to the person involved with the screening committee, Mike Elston, and protested about that. He appealed it. In some cases, he was successful.
He appealed it to whom?
To Elston. He appealed a decision that was made to deselect a candidate for the civil division who was eminently qualified.
When you say he appealed it, whom did he appeal it to?
Michael Elston, who was the chair of the screening committee. He appealed the deselection.
And what was the result of that effort by Mr. Keisler?
I think in that case, the appeal was successful, and they were allowed to interview the candidate. He also discussed holding a meeting to discuss these issues, and he raised objections to it. I believe that what Peter Keisler did was appropriate and laudatory, and that he should be praised, and I wish others had done similar things. There were some who did it. Eileen O'Connor from the tax division, career attorneys in the tax division and the civil division, but others didn't, and I think that was part of the problem as well. Peter Keisler did and should be credited for that.
Well, praise is fine, but how about promoted?
It's not my ability to promote him. I tried to provide the facts.
You're not going to comment on his qualifications to be a circuit judge in the District of Columbia?
No, I really don't think I should do that. I can comment that every dealing I've had with Peter Keisler has been professional. I've been tremendously impressed with him. I think he's a straight shooter.
Well, Mr. Fine, that's close enough as the expression goes for government work.
Yeah, well, those are the facts, and I try and bring them to you. So.
Well, I appreciate that, and I appreciate your candor, Mr. Keisler, and I have pursued that a little more so because I've interviewed him, I've talked to him, gone over his record with a fine-tooth comb, and hope yet that before the 110th Congress ends, we can break the judicial impasse and confirm people like Peter Keisler and others. And I think your report, since you're noted for objectivity and very, very factual as to what he did here, is a strong recommendation inferentially all on its own, on the facts. That's the best kind of a recommendation. Thank you, Mr. Fine. Thank you, Mr. Chairman.
Senator Leahy and I believe Senator Specter need to be on the floor because of legislation now of this committee that's being considered on the floor. With that, I would recognize Senator Whitehouse.
Thank you, Chairman Cardin. First of all, thank you, Mr. Fine, for the work that you've done. I appreciate it very much, but I have to say it is creepy to read your report and see what was done. I served in the Department of Justice for 4 years, and my sense was that no matter how ardent the politics of any administration, they knew there were certain things you just don't do. There are certain institutions you just don't taint or ruin. And the Department of Justice was obviously one of them, probably the most significant one. And so the fact that this happened really shows that when it comes to politics, this is an administration that has no gag reflex. And it was brought home particularly in your description of, I mean, if there's one area where the Bush administration would like to identify itself as being involved and interested and effective, it is counterterrorism. And yet, where a truly experienced, highly regarded counterterrorism prosecutor is up for a position, that person got knocked out for somebody who had essentially no qualification whatsoever but the political qualification. And I can't help but remark on the priorities that that choice reflects. The concern I have is that for all that was done in the past, and you've done a wonderful job of shedding some light on it, the present Attorney General's position appears to be, we will sin no more. And I believe that he's kept his word on that. The problem is that there is a residue from what was done before. As you said, it was serious. It was significant. It was systemic. And the idea that it had no effect that lingers in the department, to me, is just not realistic. And I see in particular, there were a number of people who were hired into the department who are presumably still there, hired through a civil service system that was corrupted in this case. There were immigration judges hired, I believe, as you note, several instances in which they were hired without even interviews or without even reference to the Executive Office of Immigration Review. We count more than 20 judges appointed under this process. Some, there was a little bit more screening, but some, it appears to have just been a slam dunk by the politicos. Can you guarantee us that those people are all qualified? And setting that aside, is that really the correct standard, or should there be some consequence for folks who come through what purports to be a civil service process but is truly a bogus one, and now hold a position that grants them civil service protection that they frankly don't deserve by virtue of the discrepancies from a proper process by which they were hired?
So, well, Senator Whitehouse, can I guarantee that all are qualified immigration judges? No, I can't. I do know that some of them, after they were hired, very few, didn't survive the probationary period and are not there anymore. I also know that some are, according to the Executive Office for Immigration Review, are doing well and have been good judges. I think it is a concern. That's the harm of this process, because they weren't required to compete against all the other qualified candidates who didn't get an opportunity to do it. The department has changed the process and is now hiring according to what I believe is an appropriate process. You are right, there were approximately 20 to 40 or so immigration judges identified by the process. Not all of them were selected, and not all of them are still there, but it is a small number. There are about 230 or so immigration judges in total. So while that's not solace for how the process worked, it is not an overwhelming majority of the immigration judges who obtain their positions through this flawed process. You are right, they do have civil service protections, and it would be difficult, if not impossible, to sort of look to see ex post facto, are they qualified now? I think the important thing is for the officials in the Executive Office for Immigration Review to manage the program appropriately, make sure that people are doing the right thing, and if they're not and are not able to be immigration judges, they ought to take action.
What is the consequence? You've indicated that there's no criminal prosecution that is available. Your report points out that it was a violation of federal law to do this. I don't read in your report that there's any referral of any kind that you suggest for any legal action. It looks like they got away with it scot-free, and that the so-called loyal Bushies that they stuffed into these positions will also have gotten away with it and will be there essentially indefinitely, protected by civil service protections that they don't deserve.
Their actions were exposed and condemned. Two, the ones, at least one who's with the department should be considered, and I believe will be considered, for appropriate disciplinary action. The ones who are no longer with the department should never get a job with the department, or, in my view, any other federal agency based upon the conduct listed, and I hope they should consider this action. And there is also potential bar issues for the attorneys who have committed misconduct. And so I don't believe that they got away with it, and I believe that both our report and the actions of this committee and potential ramifications belie that.
Well, your report was certainly very important, and whatever consequences do ensue, and I very much appreciate that you've done it and the thoughtful way in which it was done. I can't resist in my last 20 seconds to just observe that you are not involved in the investigation into the Office of Legal Counsel. That is an OPR investigation, is that correct?
Well, which one are you talking about? What could you amplify that before?
I'm aware that there is an OPR investigation into the Office of Legal Counsel with respect to whether the opinions that were prepared by the Office of Legal Counsel, I think at the tail end of a process not that different from what took place here, heavily politicized, in which standards were knocked over in order to get the right political answer, whether those opinions met basic standards of legal research, legal propriety, and so forth. And are you in any respect also looking into anything at the Office of Legal Counsel, or is that solely an OPR investigation?
The investigation that you described is an Office of Professional Responsibility investigation. We don't have jurisdiction, unfortunately, over attorneys in the exercise of their legal duty. I have testified about that, and I'm hopeful, I hope, that the Congress will do something about that, because I believe that the Inspector General's office ought to have unlimited jurisdiction in the Department of Justice. We're independent, we're transparent, and there's no conflict of interest. And so I think that ought to be changed.
And you make your findings public.
That's exactly. We're transparent. We transparently provide to the Congress and others the basis of our findings, and we do that to the extent possible. And so I think that's important. I believe our office ought to have jurisdiction throughout the Department of Justice.
Well,
Mr.
OPR
Chairman,
has a chance to prove itself.
I've got a markup, and we usually run this committee by the early bird rule. I was here before Senator Whitehouse, so I'd like very much to be recognized so I can go to that markup, if I might.
Actually, nobody was here before me.
Well, you weren't here when I got here.
I was here when you got here.
You weren't sitting there.
I was sitting here when you got here. I've been here the whole time. I was here before the chairman, greeted the witness 10 minutes before the hearing.
Either way, may I be recognized?
Of course.
Senator Coburn.
Thank you. Thank you for your report. Is there anything that in your investigation here, what I'm seeing is low-level politicization and incompetence above it. Is there anything to suggest that there was some grand scheme led by the Attorney General to politicize this in multiple ways?
Well, first, I wouldn't call it low level. These are high officials in the Department of Justice. These are the White House liaison, chief of staff to the Attorney General.
Change my characterization. Yeah. Is there anything, what I'm trying to get to, is there anything in your investigation to say that the Attorney General had in plans to politicize the Justice Department?
In terms of these two reports, we did not find that the Attorney General knew about the improper political considerations.
But you would agree that there was certainly incompetence at the level of management for this to be going on with an Attorney General not being aware of it.
As I stated before, I agree that there should have been inadequate supervision. They should have known what was going on here. They should have more closely supervised the junior people who were elevated to very high positions, and I think that was part of the problem.
And you feel fairly comfortable that the things that needed to be changed within the Justice Department in light of your findings have in fact been changed in terms of procedure, monitoring, and supervision? We
have made recommendations. The Attorney General has agreed to implement those recommendations. We will continue to monitor that, but he has agreed with the actions that we suggest should occur. It does require vigilance. It just requires not simply changing a procedure, but making sure the procedures are followed, and I think that's important as well.
It requires management,
yes,
which was the reason that the Attorney General left because of that management. I have several other questions. I will submit them for the record because of the time constraints here. Appreciate the hard work. I appreciate the transparency that you bring. Inspector Generals are very important because they form the balance to stop. Nobody wants politicization of these types of positions. And the fact that we have an IG and we've strengthened that and we're going to continue to strengthen those is very hopeful, and it gives great breath of fresh air to the American people that they can see transparently what is functioning well as well as what is not functioning well within our government. And I thank you.
Thank you.
Well, Mr. Fine, first let me thank you for your report. The Inspector General is created in order to provide an independent review of compliance with rules and laws. And as you point out, your findings are open to the public, and I think it is extremely important work, and I thank you very much for what you have done. You've indicated that steps have been taken by the Attorney General to correct the circumstance to make sure that political considerations are not involved in these decisions. I want to go a little bit further. You made 6 specific recommendations. Are you confident that all 6 are being implemented?
The steps are being taken to implement those recommendations, yes.
And you will be monitoring to make sure that they are, in fact, implemented?
Yes.
Now, there are other areas in which the Department of Justice could be influenced on a political agenda where they should not, in hiring of career employees, in the agenda of certain agencies that are supposed to operate without political interference. Does your report go into that at all, and has that come up in any of your discussions with the Department of Justice as to the extent of political involvement in the historic roles of the Department of Justice?
Well, I know perhaps one of the things you're referring to is the concerns about selective prosecution and prosecutions made on political decisions.
Correct.
And that relates to the question that Senator Whitehouse asked me earlier, and that is a matter that the Office of Professional Responsibility has jurisdiction to handle, and my understanding, they publicly stated that they are looking into those things. That is something that we'll have to await their conclusions. I believe that we ought to have jurisdiction, but we don't, so we'll see what the Office of Professional Responsibility results are.
So you're not involved in any of that because of jurisdictional issues?
Yes.
Well, there's also the matter of the manner in which U.S. attorneys were dismissed, the type of cases that they were involved with. Those are all areas that you're not directly involved with.
No, that issue we are involved with. We're looking at the U.S. removal of U.S. attorneys. That happened. We're doing it jointly with the Office of Professional Responsibility. We're looking at the reasons why they were removed, and we're doing a thorough investigation of that matter, and we'll provide that report when it's completed.
Could you give us an indication as to the timing of the release of that report?
I really can't and shouldn't. I've been the IG for 8 years, and I'm often asked that question, and I'm often wrong. What I can say is we are taking this very seriously. We're moving as expeditiously as we can. When it is completed, we will release it.
Could I just get certain assurances that we will get reports before the end of this year?
I would hope so, but again, we're going to take the evidence wherever it leads, in whatever fashion it is, and we will do as expeditious a job as we can. And so I think I really ought to leave it at that, Senator Carter. And I understand your question and your reason for wanting to know, but it's probably better for me to just simply say that.
Could I ask your assurance that if there are delays put in your path by the Department of Justice or the administration, that would be brought to our attention?
We will not be shy about raising any concerns or problems or delays that are caused by outside entities.
I take that as a yes.
Yes.
Thank you. Appreciate that. You've indicated your concern about the jurisdiction of the Inspector General. We've also talked about the civil service system. Is there need or recommendations for change in the civil service system's laws in order to strengthen the probability this will not happen again?
I don't think so. I think the laws are there. They need to be enforced. They need to be adhered to. They need to be understood. They need to be managed. I think the problem was not necessarily with the law. The problem was with the application of the law by the people in the Department of Justice, which is very troubling that the Department of Justice wouldn't adhere to the law. There is one issue that I do think the Department of Justice needs to clarify and make clear. That is, when is it appropriate to consider political factors and detailees for positions in leadership offices. Some positions are policy-making, could be filled by political appointees, and if it's a detailee that's being considered, can you use political affiliations? There are others that are clearly not policy-making and should not in any way be considered a political position. For example, the ones in the executive office for U.S. attorneys that we describe. That ought to be made clear which positions and which circumstances is appropriate to consider political affiliations in detailees for positions in the leadership office. So that's one thing the department ought to do. We recommended that in our report. They said they're going to do that.
So can we count on you following up to see how they, in fact, respond in doing that? I take it that's still an open issue. It has not been.
It has not been done, but yes, you can count on us to follow up and monitor that.
And let me just underscore the point that I think Senator Whitehouse was pursuing. You have a 33-year-old ideologue that was able to rule the day in the Department of Justice, in which senior Justice Department officials either did nothing or just refused to take action, knowing full well that political considerations were being used. How was that allowed to continue? What was the motivation here? Does your report reflect that? Was this a thought that the White House was directing this to occur and therefore leave it alone, or was it a concern that certain people would infiltrate the Department of Justice that they did not want to see in the Department of Justice? So was this a reward system for political loyalty? I mean, how was this allowed to continue in an agency that has such a long history of excellence and being nonpartisan and carrying out justice?
I think it was allowed to occur because people were put in very high positions without very much experience and without very much knowledge of the traditions.
But in high positions by whom?
By people in the Department of Justice, by others, and I think that they did not understand the traditions of the Department of Justice. The tradition of the Department of Justice is that it is different, it is special, it is not partisan, and when you come to the Department of Justice, you put that behind you, particularly in career positions, and that you do not try and infuse those kinds of decisions with political considerations, particularly hiring of career people. And the people who came did not understand that, did not appreciate that, and as I stated before, were not monitored and were allowed to run uncontrolled, which was very, very troubling. And then these actions happened, and the people at the top, including Attorney General Gonzalez, said he wasn't aware of it. Well, that's a problem. That's a very significant problem. And I think that it has created a damage to the Department of Justice that I believe and hope we will get over, but it's very troubling.
Senator Schumer.
Thank you, Mr. Chairman, and I apologize to the witness. We have a joint economic committee hearing at the same time, but I took a brief break because I wanted to be here, and I want to thank you, Mr. Fine, for your staying on top of things and doing your job as IG, which I know requires a degree of independence and a degree of courage, and I think you've shown both. I have a few quick questions. Although we've long known about the unprecedented political decision-making in the Justice Department, the details of this report are a new low. Over a year ago, when I held the first hearing to look into the suspicious firing of several U.S. attorneys, none of us knew that this committee's investigation would implicate much of the department's senior leadership. We heard early on that Monica Goodling might be one of the bad actors. That's why I urged Senator Leahy to add her to the list of witnesses to subpoena, and now we're all rightly appalled by this account of how decisions in the Justice Department were made based on political considerations rather than individual qualifications. And here we have a great civil service. Senator Whitehouse, Senator Cardin know this well, and I hope they're not leaving because of my speeches. No, I know we have a vote, so go right ahead. They know this well, but I just find it despicable that senior Justice Department aides broke the law, sullied the reputation of the department and of thousands and thousands of people through Democratic and Republican administrations alike who just labored and did the right thing, and now may be getting off without punishment because they left the department, even though they resigned in disgrace and at the height of a scandal. But these revelations are not just a blow to the department's reputation, but they also affect our ability to keep the country safe, it seems. Because as you report, Ms. Goodling would not let a former U.S. attorney from Western New York Mr. Battle, hire his own assistant because she believed that his preferred candidate had not proved himself to the Republican Party. Another qualified New York candidate, a winner of the Attorney General's Award for Exceptional Service, was rejected for a top Justice Department counterterrorism position because of his wife's Democratic political affiliation. Because of this, a vital counterterrorism position was filled by a person at the department with no experience. So this is not just politics. This is our own safety. When you have less qualified people, if we had politics and equally qualified people, it would be one thing, but you have less qualified people trumping more qualified people because of their political affiliation. And that hurts every one of us in terms of safety and security and the jobs of the Justice Department. And so most members of the department, for instance, believe that that person in counterterrorism was undeniably unqualified, but they met Ms. Goodling's ideological test. That's beyond disgraceful, in my view. One of the most shocking conclusions in your report is that someone like Monica Goodling, who politicized the appointment of assistant to U.S. attorneys, immigration judges, and even counterterrorism positions, may not face any real consequences for her actions, simply because she already left the department. Our current law, even though these people broke federal civil service laws and trampled on the department's own standards, they need only change jobs to escape real accountability. It could be that someone could leave while you're doing your investigation, or even the day before you issue your report, and escape any punishment whatsoever. So let me ask you this, Mr. Fine. Should such blatant politicization and illegal activity be subject to some criminal punishment so there would be ultimate accountability? In your view, would a criminal penalty, say a misdemeanor, help prevent such behavior in the future, work as a more effective deterrent, and provide better accountability? I'm sure it sticks in many people's craws that these were horrible things that were done, and because simply you resign from the department, you escape any punishment.
Well, let me talk a little bit about the premise of the question, then I'll get to whether the law should be changed, my view on that. I'm not sure it's true to say that she escaped any accountability, any punishment. As I discussed with Senator Whitehouse earlier, people did leave the department, so they can't be disciplined by the department, but we've recommended that they never get a job with the department again, and hopefully never with the federal government again, that they consider this report if they ever do apply. They have been exposed. Their conduct has been exposed in a transparent way for all to see. And then there may be, I'm not saying there is, but there may be appropriate bar sanctions possibly for attorneys who have committed misconduct and may have violated a bar rule, and so the bar may look into that. There is no criminal punishment that we see for this conduct. Now, should there be criminal punishments? I'm not sure. To criminalize violations of civil service law might expose a lot of people to potential misdemeanors in circumstances not like this. So I'd have to think more carefully about that, but my initial reaction is we have the civil law and the criminal law, and there ought to be that separation. But I recognize the concern about accountability, and I believe that the comments that I made about the premise will...
and, you know, even aside from discretion, in other words, a minor violation without real intent different than this might not be prosecuted, I'm sure there's a way to draft the law to make it a misdemeanor if it was repeatedly done. I mean, there are ways to set standards so not every civil service violation would be a misdemeanor. Don't you think?
Yes, but when you draft it that way, I think you can sweep in conduct that you may not want to have criminalized. And there are a lot of difficult issues in the civil service law. This one, I don't think, was a difficult issue, but when you make a statute to cover the civil service law, you could create
Well, it's something I'm exploring, and
I
I'd like to continue the dialogue with you.
Certainly.
Okay. One other question. Did we start our vote? We have not started our vote. Okay, good. So this is about borrowing. As you may know already, Senator Feinstein and I wrote a letter to the Attorney General last week, and this is before your report came out. In the letter, we asked the Attorney General to investigate instances of borrowing in the department where political appointees are then given career positions and continue to assert influence during a future administration, even though that candidate may not be the most qualified. Now, our letter was based on a report by the GAO that found the department was engaged in improper hiring procedures, like refusing to award our war veterans consideration they deserve and are legally due. So we are acting, that is Senator Feinstein and I, proactively to ensure that career positions in the federal government are filled by the best individuals available and in accordance with federal law. Did you find any overlap between the GAO findings and the particular instances of politicization in hiring that you've been investigating?
Well, we didn't look at that issue of burrowing, but I think the sort of same principles apply and the same concerns apply. That is, if you're using any considerations other than a fair and open competition and merit-based based upon the skills, knowledge, and ability of someone, then there can be those kinds of problems. I do know that the GAO is opening a review of this and has done reviews in the past, so I think that's important to maintain transparency and scrutiny on that subject, and I think that's an important issue.
Thank you. My time has expired. Thank you, Mr. Chairman.
Thank you, Senator Schumer. Just to follow up on the discussion with Senator Schumer, and with respect to the consequences of these violations of federal law, first of all, can you identify what bar rules might have been broken? I did not see, this is an OIG-OPR joint report, correct?
Right.
I did not see OPR making any referral to disciplinary counsel as a result, so I'm a little confused about what disciplinary consequences lawyers might face for their role in the administrative process of hiring, and if you're confident that there might be those processes, why the OPR side of this didn't make any referral to local disciplinary counsel.
My understanding is, and I've had discussions with OPR about this, that OPR intends to, and we will participate in a notification of the bars of individuals who are found to have committed misconduct for them to review the conduct. Now, I don't believe OPR has done a lengthy review of this and say which exact rule, but it does intend to, I think it is appropriate, to notify the bars of the individuals who are involved. And in fact, I think some of them have already been notified. I've read that individuals have provided our reports to various bars for the bar to look at. In terms of the rules, I'm not an expert in the area, potentially Rule 8.4, which talks about the administration of justice and acts going to the fitness of an attorney to practice law. I'm not saying that necessarily does apply, but I think there are things that ought to be reviewed and looked at, and the experts in this area ought to do that.
Okay. And following up on my discussion with you and Senator Schumer's discussion with you about not only consequences, but also, I guess, deterrent effect or motivations, if you are not enthusiastic about any criminal penalty, even at the misdemeanor level, for a deliberate violation of the civil service hiring laws, would you think that it might make sense to strip from individuals hired pursuant to a deliberately flawed process the protection of those civil service laws until they had gone through a legitimate process? It strikes me that if something like that were set up, you know, this isn't done just for fun. This isn't done just because somebody has an idle hour. This is done in order to achieve political ends. And the end is to put certain people with certain ideology in certain positions. And if the folks who are going about doing that were understood that by virtue of distorting and compromising the civil service hiring process, they were actually denying the folks that they'd be planting in the civil service positions the benefit of civil service protection, it would seem to me that it would operate as a counter-incentive to these sorts of attempts to suborn the, or subvert, I should say, the civil service system. Would you
I'd have to
Have any
think
thoughts
more
on
about
that?
that. That's an interesting proposition.
It takes the prize out of the game, basically.
I'm not sure I'm ready to sort of answer that question off the cuff. It's an interesting
well,
proposition. I would say that I'm not sure that all of the individuals who were selected knew about the improper procedure that was used. Maybe some of them did. I'm not sure all of them did.
No, and to a certain extent, it would be their bad fortune to have been on the losing end of this. But from a structural point of view, it would take away the incentive, the prize, if you will, of the game for those who are manipulating or compromising the civil service process to political ends.
That's true. There's one way to do it. I would hope that the department would do it directly and prevent the people from actually doing this, so we don't have to get to this
Yes, that would be
after the
best.
fact review. But I understand
We missed
your
that
point.
in this case.
Yeah.
The last question that I have has to do with, you indicated on a number of occasions in this report that people gave statements to you in the course of their interviews that you described as inaccurate, and in some case described rather pointedly as inaccurate, and in what looked to me to be circumstances in which it was a little hard to believe that it was an innocent mistake. And my question to you is, are the interviews that you conduct within the ambit of 18 U.S.C. 1001, the False Statements Act, and do you have a process for evaluating whether inaccurate statements provided to you in these interviews amount to a false statement under that act? And what is that process for such inaccurate statements? How do you get from you just saying it's inaccurate in the report to a referral of some kind for some prosecutive official to look at whether that criminal law was violated?
Well, they are within the ambit of Section 1001. A false statement to an OIG investigator is covered by that statute. And we do analyze that. We analyze whether the evidence is sufficient to prove beyond a reasonable doubt that the statement both was inaccurate, the very specifics of the statement, and you being a former U.S. attorney know the difficulty. You have to be very precise about what the question is and what the answer is, and it has to be inaccurate and false in all respects. And then we go to the sort of the intent of the person, whether it was a mistake or whether they knew it was inaccurate, and we can prove that beyond a reasonable doubt. So the same processes that an assistant United States attorney would use, and we do have assistant United States attorneys, very experienced ones on our staff who have done this over their careers, do that analysis.
So is it safe then to conclude from the report limiting itself to only describing these statements as inaccurate and not making any further referral or not discussing any further whether the statements might merit prosecution, that you did in fact look at that and that the conclusion that you drew was that these statements, however inaccurate, did not amount to what an assistant U.S. attorney preparing a charge would consider adequate to bring that charge under 18 U.S.C. 1001?
That's correct.
Okay. Very good. Well, we have this vote, and everybody has gone towards it, so I'd probably better do the same. I would like to, with unanimous consent, insert into the record, on behalf of Chairman Leahy, a number of editorials from papers around the country, including the New York Times, the San Francisco Chronicle, the Washington Post, and USA Today, that have editorialized against the partisanship of the Ashcroft and Gonzalez regimes and called upon the current Attorney General to take action in response to these alarming reports and hold people accountable. And a selection of these will be put into the record. The record will remain open for 1 week in the event anybody wishes to add to it. And if there is nothing further, again, with my grateful appreciation not only to you, but also to the, I assume, very busy and hardworking staff members of the Office of Inspector General of the Department of Justice. You have done your own office and the department, I think, considerable good with this report, and I hope you feel considerable pride in it. I think that many of us do. Thank you.
Thank
Hearing
you.
is